You in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and today's class is called the AP Court Case Review. So these are major landmark cases that will be on the AP GOPO exam. Yes, I know that sounds a little weird, but it's the advanced placement exam that so many high school students across the country are taking in early May. So we have learners of every age in here, but we also have students who are prepping and getting themselves ready for this test. And so we're going to give them some sneak peeks into the cases and ways to connect the dots. Now, I'm so excited that I'm not alone doing this today, but I have an amazing professor with me. So I want everybody to meet Professor Fredrickson, who is a distinguished visiting professor from practice at Georgetown Law and a senior fellow at the Brennan Center for Justice. I feel like this is our highest level AP prep that we've ever done. So thank you so much for being with us today. And do you want to say hello to the students?
Hi, it's great to be with you. And it's terrific that you are so focused on studying our government and our constitutional structure. And I hope you'll carry on and engage in those issues going forward in your lives.
And I think that's a great lead in. So when we, our students are going into this test, they're really nervous, but in all honesty and all the data, because you all know I'm research data, that the work that you've already done to this point, that's the skills that you have to go into life using this. So don't worry about the tests. The test is just a marker, but doesn't actually show your brilliance. You've already gotten to that point. So breathe, have fun as much as you can, and we're going to have fun today. So here are the list of cases that we're going to go through today. So 14 cases. Last year and in previous years, the case of Roe v. Wade was also a case. And the AP test is no longer having Roe v. Wade. And one of the reasons for that is the Dobbs decision. So Professor Fredrickson, did you want to talk a little bit about how the Dobbs decision affected the Roe case in looking at precedent? Because that was the question that they typically had around Roe v. Wade. So you want to take one beat on that before we dive into this listing?
Sure. In the Dobbs case, as you all may know, the Supreme Court reconsidered its finding in the Roe versus Wade decision that a woman's right to have an abortion was a protected fundamental right under the Due Process Clause. In their argument about why they would reverse precedent in that case was because it was not appropriately decided initially. And so they reversed and said that it was a matter for the states to determine.
Awesome. Thank you so much. And students, as we go through, if you have questions, you can put them in the chat. I'll try to either weave them in or save them towards the end. Okay, so we're ready. We ate our Wheaties. Let's dive in. So classic Marbury versus Madison. The AP government test looks very closely at the separation of powers. So it first wants to look at this case and have students answer questions around the judicial branch, but also judicial independence, judicial review, and how that's connected to separation of powers. So Professor, you want to walk us through what the story, it's a great story, the story of this case is, and then how students should understand judicial review, judicial independence, and the connection to separation of powers.
Right. Well, telling you the full story of this case would take most of the time that we have today. So the main story of this case is that we have the issuance of a commission to a justice of the peace, which was not delivered. So there's a very elaborate story that has to do with politics and American history, but the basic question really, boils down to, does the Supreme Court have the power to declare an action unconstitutional? In the Marbury case, Chief Justice Marshall said, in fact, we do. It's the province of the judicial branch, he said, to determine what the law is. What's important about that is that there's nowhere in the Constitution that it says that it's actually the role of the Supreme Court to act on to determine whether acts of Congress or actions by the executive branch violate the Constitution. So that was has been seen as a very powerful moment, but it has really gone unquestioned. The other part of that case that's really important is that the Chief Justice also indicated that the court had the power to tell the executive what to do. So in both senses, the Supreme Court was policing the other branches. So this is why it's seen also as such an essential part of separation of powers and checks and balances.
Fantastic. And as we go through these cases, one of our teachers, Ryan, pointed out that sometimes the students have to actually cite the clause and what part of the Constitution. So if you don't mind, when appropriate, connecting those dots too, that would be fantastic. So a lot of weight on you today for this. This process.
Absolutely. Well, that's the harder part with Marbury, because it's not stated that there is judicial review in the Constitution. So it's more implicit in the idea of separation of powers.
And students, that's a great thing to point out in your written responses, is that you can say that we're not looking at a clause here, where they're looking at an interpretation and an implicit right. Okay, federalism is our next big area that the test focuses on. And that idea that we just don't have separation of powers amongst the national government between Article 1, 2, and 3, but among the national government and the states. So the two cases that they bring out here, and I always find that they're like bookends of the timeline, McCulloch v. Maryland, and then the LOPEZ case. So let's begin and dive into McCulloch v. Maryland.
Sure. Well, what's really interesting about this case is this involves the establishment of a national bank. And the state of Maryland, obviously, since McCulloch versus Maryland, decided that it was going to tax this bank. And the question was, can Maryland tax the bank? And also, can the federal government set up a bank at all? So there are two questions involving the power of Congress and involving federalism. So in terms of the power of Congress, the Chief Justice, the court found that there was, under the necessary and proper clause, that the necessary and proper clause enabled the Congress, using its Commerce Clause power, to set up a bank. Because again, it's not explicit that the Congress can set up a bank, but inherent in all of the other power, in the need to establish a national economy and to carry out its other functions, establishing a bank was something that could be seen as necessary and proper to the end of establishing a national economy. The question is, can Maryland tax that bank? And the Supreme Court said in that case, no, Maryland cannot tax that bank because that would be invading the powers of the Congress. And in this area, the power to tax is the power to destroy, said the court, and it would undermine the ability of the court to bank to function if, in fact, it was going to be taxed by all of the states. And so it established the idea of that the federal government, even though it is a government of limited powers, that it can, in fact, set up this bank and that cannot be destroyed or resisted by the states when it's appropriate use of the federal power under the federal Constitution.
Fantastic. And
I'm sorry to state that would be Article 6, the Supremacy Clause, which is being promoted in the McCulloch decision.
Perfect. Thank you for that. And students, I am going to get the transcripts for this class and send them to you all too, so you can kind of pull out the big ideas on the written, lots of modalities is what we like at the Constitution Center. Now, kind of the other side of this timeline, United States v. LOPEZ. And when you dive into this, because you also I never teach this case alone. I typically talk about Wickard v. Fillmore and LOPEZ. So sorry to make you double case on one slide, but if you wouldn't mind talking about the two. Well,
sure. This case really marks a change in interpretation of the Commerce Clause by the Supreme Court. We talked about McCulloch, which was followed by, which around the time of Gibbons versus Ogden and so forth. And there just wasn't as much commerce, though, and as much statute making by Congress during the 19th century, but during and around the New Deal period, there was a lot of the nation had grown. There was need for nationwide legislation regulating the economy, and the Supreme Court was very resistant. However, due to a lot of history and politics that we don't need to go into now, Supreme Court changed its interpretation and gave Congress very broad power under the Commerce Clause. That was true until we came to a series of cases starting in the 1990s, and Lopez is certainly one of the most famous. But Wickard, which Professor Sautner talked about, was one of the famous New Deal cases in which it said the court agreed that there could be regulation of the growing of wheat by an individual farmer, even if the farmer was growing it only for his own consumption, and that still affected commerce. And that was seen as kind of as a major change in interpretation of the reach of the Commerce Clause. Well, Lopez really starts to turn back the clock to a time before Wickard. And in this case, as you can see, the Congress had tried to set up a gun-free school zone. And Alfonso Lopez had been arrested for carrying a concealed weapon in his school. And so he was charged under this federal law, which was passed in 1990. And he challenged that. He challenged the Article 1 authority, the Commerce Clause authority, to reach so far as to regulate carrying a weapon in a school zone when there was no commerce aspect to it. And the Supreme Court agreed in that case and say that the Commerce Clause does not reach that kind of activity.
Fantastic. Okay, the next grouping really looks at with the College Board talks about a balance, order, and liberty. So the first three cases are going to actually be school cases on the First Amendment. And so we can look at those three in the first kind of bundle together, but we're also trying to really understand the difference between, you know, the rights of the whole and the rights of the individual. So they talk a lot about civil liberties. And Professor Fredrickson, just last week, I was in a conference in Utah, and teachers were having difficulty trying to understand the difference between a civil right and a civil liberty. And so could you just take one beat on what the difference, what is a civil right, what is a civil liberty, and then we'll break down into these 5 cases.
Sure. Well, and that's a very good and difficult question, but I think the easiest way to understand it is that when we think of civil liberties, we think about it as being the government's restraint from interference. And when we think of a civil right, it's some kind of a more a positive right that we have to assert. They're often have many issues that could be probably characterized as both a civil right and a civil liberty. But to make it sort of more clear, if you think about the major areas of civil liberties would be freedom of speech, freedom from surveillance, issues around government interest in searching your personal possessions, spying on what you're doing, or telling you what you can't say. So really speech but again, I would say that the easiest way to describe it is the assertion of government power into your private life, as opposed to you could say, I have a fundamental right to vote. I have a right to vote. It's not a liberty. It's a right to vote because it's mine, something that I possess, as opposed to I'm trying to stop the government from doing it to me.
That's fantastic. That's really helpful too when we think of these first 3 cases. So these 3 cases are dealing with children in schools. And it's almost like, does the government have the right to reach and tell your child what to believe, what to say, and how to think? So that I love that framing. Very helpful to look at these first 3.
Mm-hmm. Well, so if you think about it in that light, the first one, the Engel case, is about the government telling the students what to do and what to believe, because it involves a school imposed, or it authorized the schools to recite a short voluntary prayer at the beginning of the school day. The students didn't have to pray, but they were there. There's always been a special solicitation or solicitousness for the the vulnerability of children, especially when it comes to the imposition of ideas that they might, their families might not want them to hear or share in. But this idea that the children, whether they're there and they're praying or not, they're surrounded by other children who are praying, that has a real impact. And so in this case, the Supreme Court found that this school sponsorship of this prayer violates the Establishment Clause, which is part of the First Amendment. There shall not be, the government shall not establish a religion. And by having a prayer, even if it were non-sectarian, it would be establishing a religion in some sense.
Now, Brian was pointing out, one of our teachers, that it's great to connect to non-required cases. So would this be the Kennedy case from last year? Would be a nice one the students could connect to? Yes,
and that's where things get a little blurry. In the Kennedy case, we had a coach who was praying at the end of games or at halftime on the 50-yard line, and many of the players, as football coach, many of the players would join him. And the question was that prayer the school sponsorship of a religious activity in the way that this prayer here that you see the picture of, where it was actually done at the beginning of the school day inside the classroom. And the Supreme Court in that case said no. It's very controversial, again, in part because of this idea of the vulnerability of students, the pressure that the peer pressure that could be applied from the students who don't want to go and pray. For example, they're not of the same religion. I believe Mr. Kennedy was Christian, or they are not believers at all, but there is the kind of pressure to join. So there was a lot of criticism about whether or not this was that the Supreme Court did not adequately allow for that kind of pressure and impact on students, and looked at it as solely a non-school voluntary activity that was not done under the auspices of the actual governmental institution.
Perfect. Okay, so the next case we're going to look at is the YODER case, and really looking at not just the right to, so many times we talk about the right of education, the right to go to school, to have civic education, but the other question around this is the right to say when you don't have to be forced to go to school anymore. Mm-hmm. So tell us a little bit about this case.
Right, when the Amish families did not want their children to go to school after 8th grade, and they were being compelled to put their children in the public school system, and they protested. And in this case, the Supreme Court upheld their right. And this is, I say a right, because this is, in this case, you might go back to that same distinction between a right and a liberty, the right to practice your own religion. So the free exercise clause of the First Amendment, it's the flip side of the Establishment Clause. The government can't establish a religion, and you're allowed to practice your own religion. It's an interesting historical aspect. In the Constitution, Madison had wanted to insert protect freedom of conscience as well. That didn't make it into the final draft, but it is sort of a backdrop to this, is the idea of freedom of conscience, that the government can't force you to think or believe a certain way.
Perfect. Now, our last case is looking at the Tinker case. And again, any other cases that we can look at connected to Tinker, that really, if Tinker sets the bar of that students are allowed to have rights and political speech in schools, what is a limiting case about schools and speech? Mm-hmm.
Right. So in this case, the students wanted to wear black armbands to protest the Vietnam War, and the school district did not want them to do so. And so the question was, were they, in fact, could they be expelled for this kind? Do students have freedom of speech and protection the way that adults do? And the Supreme Court did find, in fact, that the students do have free speech rights. They're not as broad as adults. They can be limited when it interferes with the school's operations or central mission. Now, I see in the chat people mentioning Bong Hits for Jesus and the cheerleader case. And these are iterations of that same idea where the court struggles with the limiting principle about when does the activity actually interfere with school operations. I think it's a difficult question. So, for example, does outside social media use, which the cheerleader case, or was the protest or not a protest exactly, but a kind of a satirical banner that a student had outside the school, I believe, in Bong Hits for Jesus, was that a basis for discipline? And I think there's still a lot of flexibility in this area in terms of how far the student rights are. I see there are lots of questions coming in, so maybe we can get to that in the Q&A.
Yeah, we will get to them. Hazelwood's another one that I love to look at around this, and I think it leads nicely to the next case to go over. So it's very different depending on in school and out of school. Hazelwood is about a school newspaper and an article that was going to be published and what was allowed to be censored before the article was published. But then we go to this case, which, as we're talking about the cheerleader case, the praying coach case, Bong Hits for Jesus, we're all using names of these cases that aren't the official name, and that is just the way we talk about them. So this is the Pentagon Papers case, as we keep going with that two sides. So this New York Times and Company versus United States. So tell us about this public newspaper.
Right. So this is, I have to say, all of you who haven't seen, there's a bunch of great movies about all the this era involving the Watergate and the Pentagon Papers and so forth. The movie called The Post. There's the All the President's Men that tell a little bit. The Post is particularly interesting in describing this story as Daniel Ellsberg, who had worked in the government, in the Pentagon, or he was at the Rand Corporation, but he was working with the military during the Vietnam War, and he became very disillusioned with the war, in part because he saw the information that was being suppressed by the U.S. government about some of the real setbacks in Vietnam, and in order to keep the war going, and so he started to leak this report and leaked it to reporter Neil Sheehan, and that's important to me because his daughter's a really good friend of mine. So I have met him, and he was it's a very heroic. But as this was being published, the Pentagon tried to squelch it. And the question here is really, can the government come down and prevent something from being published, as opposed to suing after the fact for whatever damages they sought, a restraining order, using the Espionage Act, and the Supreme Court said that unless there's a grave danger, that they were not going to allow for prior restraint. That would be such a violation of the First Amendment. The First Amendment protects freedom of religion and prevents the establishment of a religion. And it also protects the freedom of the press and freedom of access to information. And that was gravely implicated in this case, without showing that there was going to be some kind of harm, because I think the next case we're going to talk about says that the Supreme Court doesn't say that anything, you can say anything, because in the Schenck case, they set up this clear and present danger test. It's sort of the easiest way to remember it is that Schenck stands for the proposition that you can't yell fire in a crowded theater, right? You can't put people's lives in danger in such a way. You can't reveal information that's going to enable an enemy to have access to information that would really harm us. In the Pentagon Papers, the reason why they didn't find that was that this was old news. It was just revealing embarrassing things about the government. It wasn't really revealing things that were going to put us, Americans or our troops or other interests in harm's way.
So do you want to give us a beat on Schenck and maybe a little bit about Brandenburg and a case that kind of connects to Schenck?
Sure. Well, with Schenck, this is, with these, the defendants were sending around information they were trying to obstruct the military draft in violation of the Espionage Act of 1917, which made it illegal to convey information with the intent of interfering with the operation of armed forces or obstructing recruitment. And in that case, Justice Holmes, Oliver Wendell Holmes, upheld the convictions and said that the Espionage Act does not, in fact, conflict with the First Amendment. And then they established this clear and present danger test, where the test basically boils down to, as he said, are the words used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It's a very important case. Now, that has been really restricted in many ways. They haven't overruled this case, but it's been, and I think the New York Times versus Sullivan case shows very much it understood in a very much more restrained way, because obviously the clear and present danger test as applied to these particular individuals could be seen itself as a stretch. And so particularly during the 1960s, and with the Brandenburg case, the Supreme Court really advanced a very different idea of free speech protections, and that is now Brandenburg would suggest that government can't shut down speech unless the speech is, quote, directed to inciting or producing imminent lawless action and likely to incite or produce such action. So those are really important verbs there: incite or produce. And also the imminent is a very important word there. So I think, focus on that's what, the Supreme Court is looking at in order to restrict speech now, inciting or producing imminent action. So, so very much of a kind of, again, a kind of a broadening under the First Amendment. This has been a story as opposed to the Commerce Clause, which has gone in the other direction.
All the zigzags of constitutional history keeping us on our toes. Now, I think we're down to the bottom four. So these two are grouped around incorporation. So looking at so let's start with what is incorporation? What does that mean? And then why these two to talk about selective incorporation?
Well, it's a really interesting moment for this question right now. So the incorporation is the understanding that when the 14th Amendment was adopted, it incorporated that would start to apply to the states, the provisions of the Bill of Rights. Sounds crazy, right? We just assume that now, that the Bill of Rights should apply to all state activity. Well, in fact, it still doesn't, not all parts of the Bill of Rights apply. It's only been selectively incorporated. And just this week, I was thinking about this in the context of some ongoing big news that the grand jury requirements of the Sixth Amendment have not actually been incorporated against the states. So just a little interesting constitutional footnote. In Gideon versus Wainwright, this involves the right to an attorney for those who can't afford it under the Sixth Amendment. So the court found that the right to counsel was in fact an incorporated right And so Mr. Gideon was in fact entitled to counsel in his state felony case.
And as we were on a movie list, Gideon's Trumpet is also a great movie, great book, great movie, like another like list of movies for the weekend.
Yes, absolutely.
You know, when we talk about McDonald versus Chicago, so many times the case of Heller is the one that so many people know. But this one's really important because it talks about Heller, the ideas behind Heller, but also with incorporation. So could you tell us about both of those cases a little bit?
Well, Heller was very important because it reversed, basically 200 plus years of precedent, which said that the Second Amendment was not an individual right. That the militia clause was not a provision to be ignored. It actually had meaning, that there could be regulation of access to guns. And oh yes, sorry, somebody correct me. Grand jury is the Fifth Amendment. Sorry, I meant the Fifth Amendment. But they recognized that this was an individual right under the Constitution. The McDonald case was the incorporation case, in which that understanding of the Second Amendment was applied to the states. And so in this case, Chicago's efforts to restrict access to handguns was limited by the Constitution.
Perfect. Okay, we are moving now. Actually, I lied. I think we have 3 more cases, so I couldn't do the math right. So the big equality case that the College Board looks at for the AP Gov class looks at equal protection clause and is Brown versus Board of Education. But again, I'm going to do a double for you there. I can never look at this case without looking at Plessy versus Ferguson. Mm-hmm. So can we connect those 2 cases so the students can use?
Absolutely. Well, so this involves the issue of whether separate can be equal under the 14th Amendment's Equal Protection Clause. And Plessy versus Ferguson had held that, in fact, yes, separate can be equal. But in Brown versus Board of Education, the Supreme Court said no. In fact, school segregation violates the Equal Protection Clause. Separation cannot be. It's inherently unequal because it creates all sorts of biases and prejudices against the group that is excluded. And so it led to the requirement of desegregation of schools in the United States, and was followed by a whole series of cases that tried to police the very slow process of desegregation that happened. And basically has been very much limited by a subsequent Supreme Court case called Seattle School District, which now makes it very difficult to engage in desegregation efforts in the public schools.
Perfect. And now moving to the Citizens United.
Well, Citizens United is they're probably, you all have heard of all of these cases, but for most Americans, if they've heard of a few cases, Citizens United tends to be one of the ones. And it's quite important for finding that free speech rights are not solely individual rights, but also are affect or belong to corporate interests, and that corporations are just groups of people and thus have First Amendment status. There had been a law dating from 1906, actually passed by Teddy Roosevelt, that restricted labor unions and corporations in giving contributions to campaigns. And in this case, it really started to undo the idea that free speech was an individual right for human beings, but in fact belongs also to corporations, associations, and labor unions. So it's very significant, and it's had a lot of significant cases that have come afterwards involving independent expenditures and all sorts of things. But it's quite a significant case in that regard. There are still some restrictions on campaign funding, and that is particularly donations. two candidates are still somewhat limited by the Supreme Court. But this really started this process of according free speech rights to corporations for political speech, started with the case Buckley versus Vallejo, in which the Supreme Court really differentiated an equal protection kind of argument from the free speech argument. And they said, even that's not thinking about equal protection. That is, does it make the playing field unequal or slant, tilt the playing field against the people who don't have as much money? And they said that's not a valid consideration. The consideration is speech. And thus, when you are engaged in political activity that is running advertisements or sending out mailers, that's speech. And that is the core of speech really is political speech, and thus cannot be regulated.
This is fascinating. So our students are trying to grapple with why all these cases together? What are the big ideas coming out of this? And so much of it, as they pointed out in the chat, is First Amendment, 14th Amendment, but I'm trying to pull the bigger ideas out. And there's definitely a freedom of thought, freedom of speech, a right to and a liberty from. But these next two cases are also about representation and fairness in the process of representation. So can you talk a little bit about, and this is how the College Board tried to pull in this idea of a Republican idea of representation or representative government. Can you pull out one of the big ideas here and then go through Baker v. Carr and Shaw v. Reno? But I really appreciate how our kids are processing, our students are processing the ideas and looking for those themes.
Well, so Baker versus Carr is most famous for establishing the idea, the beginning of the idea of one person, one vote. The factual background is really interesting, involves the state of Tennessee. Tennessee had established its apportionment of its state legislature. Oh, thank you. That's even great. That's better to have that map. In which they had not adjusted the boundaries for 6 decades. And this meant that the rural areas were much more represented than the urban areas because of the increasing urbanization. I see Nashville there, Memphis. I think there is also a backdrop here of as many cases around this era of civil rights more generally, of the overrepresentation of the white rural citizens of Tennessee versus the more urban Black citizens. So there had been no effort to redistrict, and the question was, or to reapportion the state, was this a violation of equal protection? Because each vote of the people in the cities was worth a whole lot less than each vote of the people in the rural counties, or the rural districts. And so in this case, the Supreme Court did in fact say that this was a justiciable question. My students always find that's the hardest word of the semester, justiciability. So is this actually something that the court can oversee? And the court said, in fact, yes, we can. This is a question that we can get at under the Equal Protection Clause. And then this led to, in later cases, the one person, one vote, and that meaning that the districts have to be roughly equal in size in order to protect that under equal protection, that each person should have the right to vote or the same access to the vote.
And that brings us next to the same size. Sometimes can mean very different shapes, but sometimes it goes a little too far. So could you talk a little bit about Shaw v. Reno?
Right. Well, in this case challenged the idea of the creation of these majority-minority districts under the Voting Rights Act of 1965, which were an effort to ensure that there was greater representation, primarily for African Americans, through the construction of districts that kept communities together, even if the geography was a little bizarre. And the Supreme Court said that in this case, that in fact, that was a violation of the 14th Amendment. because if race is the only factor, then it violates equal protection. And so, well, they found that the North Carolina plan was perhaps not expressly based on race. The incredibly bizarre shape of that district was an effort then to impermissibly draw district lines on the basis of race. So this means that in these districting cases, the Supreme Court is going to use what's called strict scrutiny. That is, you really have to, there has to be a very important government justification. It's necessary to serve a compelling government interest. Otherwise, it's going to be struck down.
Fantastic. And I believe that brings us to the final, this is the final case. So we have wrapped up all 14 cases. Thank you so much for walking us through all these big pieces and answering our questions as we go through. I'm going to stop share for a second. Just make sure that our students, I know we ran a little over, but that's okay. If students, you have any questions in the chat, please feel free to put them in. Thank you to our teachers and our other students for sharing connective tissue and connective ideas along the way. And Professor Fredrickson, that was fantastic. Thank you so much. We always feel bad torturing our professors going through these lists so quickly, but you did great.
I appreciate it. And I appreciate the chats that popped up, and especially correcting me on the, I don't know how I said the Sixth Amendment, but the Fifth Amendment on the grand jury provisions, but lots of great comments. I'm very much a person who learns visually and orally, and so the movies for me, I think, are great. And the more you can absorb through those, there are a lot of great movies about constitutional history and the big cases. And so, if you have time in all of your studies before your AP tests, and you want to take a break, they're also great entertainment.
Yeah, and I think if there's as Ryan said, he's been an AP grader before. He said it may not get you extra points, but it will definitely make the AP grader have a better experience in grading. So maybe that'll in some way be more positive for them as they go through. So thank you so much. I thought that's really fun. We always give the students lots of ways to read, but I think it's a great way to actually see these movies as well. So I'm going to wrap up class and then I'm going to ask you Fred's question. So I'm just going to do a real